Okay. It is Tuesday, September 8th, 2020. We'll call a meeting to order. Please stand for the Pledge of Allegiance. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Born and unborn.
Okay, minutes and reports received and filed.
We have July 2020 clerk, recorder, and sheriff fees filed, and then July 2020 auditor's report filed.
Okay. Commissioner Committee liaison reports, upcoming meetings and events.
HBA board meeting this afternoon, planning commission meeting tonight. Cole County Hazard Mitigation Planning kickoff meeting tomorrow morning. I don't think I'm gonna make that out there though.
I can't.
And Solid Waste Management District Board meeting tomorrow afternoon. Do I have this on the right calendar then for Thursday, Cole County Communities? We
Yes.
finally have a meeting?
Yes.
All right. And then we have another economic development transition meeting Thursday as well. Will we having Renegade's Coffee on Friday?
I don't know, and I think it's probably KWAS time too, so I think it's your turn. But John's on vacation, so.
I got another thing I was supposed to call in Friday morning for American Cancer Society. Let's see if I can swing them both. Is it gonna be at 8?
I see, I don't know yet. I had emailed John and he's on vacation, so
Okay.
he didn't respond
I'll see
back.
if they get a hold of you and find out what time.
Seemed like it was earlier last.
I think that's about it.
Got a Parks Committee meeting today at noon and a Select Board meeting Wednesday at 11:30. That's it.
Mark Ellinger and I are doing the evening Rotary meeting tonight via Zoom. We're gonna do it on the bicentennial. I guess tomorrow, Deb, do we have the BKD work group?
I don't know.
Oh, okay.
We do, but
Oh. Okay. Then at 11:30, I've got the chamber transition, so I won't make the Cole County Hazard Mitigation. Thursday's communities, 8 a.m., right, we're doing the our CARES meeting. Yeah. And then Thursday, I also have Cap Region Past President's Luncheon at noon. And it's Linda's birthday, so I gotta remember that. And Friday's KWAS. Okay. That is all I've got. No commission. Resolutions. Mr. Hoffman, would you come forward, please? I told him I'm gonna miss him. Every time we've had to call an ambulance in my family, he has responded. So.
Yeah, Coach Fed sang the best.
They did. Okay. Whereas Ronald Hoffman has spent much of his life providing life-saving care to those in need 24 hours a day, 7 days a week. And whereas Ronald has been a dedicated employee of Cole County EMS Department since December 2009, working under directors Mike Schertz, Jerry Johnson, and Matt Lindeworth. And whereas Ronald has served the EMS community for over 34 years, with 23 of those years at Cole County EMS, and previously with Capital Region EMS. And whereas prior to his appointment with Cole County, Ronald worked with the Osage Ambulance for 13 years and Mary's Osage Ambulance District for 2. I'm going to skip a lot of this other stuff, but now therefore be it resolved that the people of Cole County do hereby thank and commend Ronald Hoffman for his years of faithful service and loyalty to the county. We also wish him the very best in retirement and many enjoyable years, as we will truly miss you. and that's the truth.
Thank you, sir.
Congratulations.
Thank you, Ron. Truly honored to have you on the team.
Yeah.
Gentlemen, could I say a quick word on behalf of Chief Lindeworth?
Yes.
As you know, he's unable to be here today because he's is on deployment. But Chief Lindeworth wanted me to present one of our Chief's Challenge coins to Ron for all of his years of service, and out of his appreciation, my appreciation, and the appreciation of the
Come back and visit.
I would like to say out in public that I think that this is the best service anywhere. I'm dang proud to be part of that team between Chief Boyles and Chief Lindeworth. You know, it's the best place to be sick because, you know, you get the best care anywhere.
Yeah.
So I mean that sincerely.
Thank you, Ron.
Yeah, thanks for making it great.
Thank you.
Thank you, Ron.
Today is his last day, so. Okay. Bids and contracts, bid award for 2020-21 video surveillance system.
For 2020-21 video surveillance system, we had 4 vendors respond, and our recommendation is to go with Midmo Telecom and Security. What do we call on that?
Yep, that's our recommendation.
I think we talked about this, and if Old Great One says this is what we need to do, then I'm good with it. That's his name.
Sundays.
You good with that, Jeff?
I'm trying to get where we were at.
I may not have it attached. Do you need a bid tab?
I may not have them attached.
Okay, this is what we talked
Yeah.
about last week then.
Yeah,
Gotcha.
yeah,
Okay.
yeah,
That's
yeah.
what I was trying to find what we had. Yeah, I'm fine with it.
I move that we award the video surveillance system contract to Midmo Telecom.
Second.
All in favor?
Aye.
Okay, do we have any unfinished business? Nope. I would look at that. You're supposed to know. New business, accounts payable review.
I'd ask for approval of accounts payable pending review.
So moved.
Did I have one in there? I didn't look at them this morning.
I think. I don't remember who had them.
We had our MAC board meeting, that's delayed. I had some mileage on there.
I'll second it.
It's not showing.
It's not on there?
Oh.
Okay.
I
Huh?
just looked at all the unapproved invoices.
I think it got approved in the last year. I'm pretty sure, yeah. Reimbursement in there.
Okay, just stay out.
I was
Aye.
abstaining.
Okay, all in favor?
Aye.
Abstain.
Okay. Internal application for CARES funding for EMS.
Okay, this was those mannequin stimulators that you guys talked about, that we were gonna go through you guys first for the approval to take it to BKD.
I'm fine taking it to BKD and they can find out if it qualifies and then we can decide after that, right?
I thought PKD,
They were working on it, but we, as a group, decided last time we were here that any of the internal applications gonna go to you guys first before we send them to BKD. Yes, BKD's already seen this one. They just, didn't know where your priorities were and/or if you wanted to submit this in as an application.
Yeah, I'm good with submitting to BKD as well.
okay.
Okay.
All, you second it?
We
Who made
need
that?
a formal vote on that, or?
Okay,
Good,
anything,
we're not taking
okay.
any action on it.
Okay, okay.
I have a
Internal applications for CARES funding for circuit court.
Yeah, I sent it to him. We're talking about the judge was gonna be here for this, and
Oh.
Kirsten submitted to you guys in an email the request from circuit clerk.
Yeah.
See the original here if you want. Again, we thought the judge was gonna be here today to
Well,
explain this.
we can table this and see if he we can call him.
I can. Anybody know his main number? I'll have Melody call. We can table it for now, maybe. Can we move it?
Yeah, we'll just go around that. Approval of CARE Act's application requests.
I guess that was, these next two are on there because we just keep them rolling in case we have any that are approved to take to you. I guess you could approve the stimulator one if you wanted to, since we're taking it back to BKD and they've already seen it. So it was basically finding out what your priorities were for those. Or otherwise, you can wait till Thursday, however you want to do it.
So I guess I'm a little confused here, Debbie. So what, you're saying stimulator, are you talking about the mannequins or?
Yes,
The ones we just said to send to BKD?
they have already seen that one, so normally that's how it would go. We bring them to you, and then we take it to BKD. This one was a little bit different. They had seen it before. We just didn't know if you hadn't seen it. So that's why we started this new process of bringing them to you, just like Circuit. You know, they're requesting money, so we're bringing it to you first to make sure it's a priority of yours, to go ahead and submit these to BKD.
So BKD's seen this, and does it qualify or not qualify?
It's the way I understand it qualifies.
They had cut it to 2 mannequins. I would kind of like to wait on these until maybe phase 3 or 4. I'm not saying we don't need them, but I don't know if it's something we have to have right now, so that's just my opinion, but, we've had them on the budget, and denied it, I think, twice, and,
The budget's gonna be totally different. This is having to deal with teaching them how to work with people with your PPE on and stuff. So by the time we need it, it's gonna be too late. So we gotta decide if we wanna do this to maybe mitigate some problems down the road. So,
they're the same mannequins we had that they requested last year and the year before, so
These are actually an updated version. These are not to argue with you, but these
Yeah.
are actually an updated version, something that our training chief, our chief of training was able to locate that would help us train staff on how to deal with COVID. Yeah, we've had simulator mannequins we've asked for in the past, but they weren't COVID specific. And it's a little different than just, there's a lot of bells and whistles that go with these, so the mannequin will actually interact to what you're doing to it and with it, so we can get more realistic training and hopefully have better outcomes with food. Just for my 2 cents worth.
So do we have a number associated with this, or I know we approved by number or by code or something previously? Guess not.
If they were on the last one or not.
here's the, D0307.
Yep, that was the original number.
And my notes are that we were gonna, if we did them, we would do 2 advanced mannequins.
It says 1 adult, 1 pediatric simulator for training. And that was $126,805.
And so I see one trauma hall adult simulator for 83,000. I see pediatric hall simulator for 43,000, and I see a hall adult multipurpose airway and CPR skills trainer for 2720 times 2. Is that all included in that, or?
What they have on the last recommendation that I have was 1 adult and 1 pediatric, amounting to the 126,803, or 805, it's kind of hard to read.
Wouldn't the airway mannequin be something critical for COVID patients possibly, or?
It is, obviously, it doesn't interact the same way as what the other mannequins do, but yeah, we felt it was all critical to Todd. The airway mannequins are just what they say, they're more multi-purpose on how to establish proper airways on people, because obviously, as you guys know, a lot of COVID people have trouble breathing, that's what it all goes down to. But the other monitors, that's something that the University of Missouri's service is using, and Jess has been in contact with them to see how those are working with their training, and I think everybody feels that it's all necessary, but the first part's invaluable. Answer your question.
I move that we approve the 1 adult simulator, 1 pediatric simulator, and the 2 multipurpose airway and CPR skills trainers.
Second.
All in favor?
Aye.
Opposed? Aye. It's not that I'm against, I'd just rather move it back to phase 3 or phase 4, so. Okay. Approval of CARES Act signing of sub-recipient
The
agreement.
judge is here.
Yeah, can we go back to the judge?
Oh, judge is here, okay.
We've been waiting for it down the list. I apologize. I was trying to knock out one more hearing before we.
That one of them, so I just picked the both of them. And if you could just explain your application,
Sure.
that what you're wanting for.
Did you email these to us?
I'll get the microphone.
Yeah,
Yes.
because I printed them off.
Christian sent it to you.
We all know that singing is a high-risk activity. Okay. As we work through the budget process, I mean, the general direction that I got was you did not want to put in the budget COVID stuff, and we wanted to see what was available through the CARES Act. And so we went back to our constituency and said, in the grand scheme of COVID, what has the effect been on us so far? How do we mitigate it, and how do we protect against it? And so this is where we came up with the proposal. We wanted to address three areas: worker safety, continuity of operations, and additional sanitizing and cleaning of our facilities. So from a worker safety point of view, we're moving clerks home. We've moved clerks home that have kids. We've already had one episode where a clerk came in who'd been exposed to COVID, and then we had to back everything off for 2 weeks, and hopefully we're loosening it up here on the next Wednesday where we can get back to some semblance of normalcy. But we're gonna have people working from home for some time. And so originally we thought about putting them out with laptops everywhere, to do that. And what we found that would probably work better is we're all using these Elite desk units, about the size of a cigar box. And then you plug your monitor in, you plug your keyboard in, you plug your scanner in, you plug your printer in. And you know, we've got limits on what equipment we can use to access OSCA because it's all about the security of the court system there. And so what we came back and looked at was what would it cost us to send home a monitor and a printer and a scanner, and you just move your box back and forth. Now, in the days when we were all with these giant computer towers, that was a real pain. These are literally about the size of a cigar box. And we went back and looked at what it would cost to do that. And, you know, at the most, it was the same price as the laptops. One of the things we ran into laptops, at the time you buy all the licenses for the laptops, that cranked the price up there pretty much. And so what we were looking at was setting it up where people can work from their home just by moving their CPU back and forth. And that's where we came up with that particular request. We'd like to 8 sites, and then pretrial's got 2 sites that they would like to consider, although I think the pretrial people would just as soon have laptops with access down there. That's the first thing. The second thing is, in the category of worker safety, is, as you're well aware, pretrial is in the basement of the courthouse where there's little or no air circulation. I mean, courthouse in and of itself is not a great place for air circulation, but at least we have some circulation on the second, third, and fourth floors. And so what we were looking at is, could we get some of these small HEPA units that we've seen some recommendations for to help work with the air in those units. When you move upstairs, and you think out of how the building's laid out, I'm really talking about my courtroom, the large courtroom that's there. That's the only courtroom we've got that can support any sort of consistent court type activity. Because when you put the social distancing marks, and if you've not been over there, we've got the whole building with blue tape marking off where the 6-foot distances are. I can put 17 people in that courtroom behind the bar. So I can literally conduct a jury trial, but I gotta do it 17 people at a time. And we'll talk about what's involved with that in a moment. They are larger units that are available. Again, we don't have great airflow. If you look at my courtroom, there's a unit on the front, I believe there's a unit on the back, but there's nothing that makes the air move back and forth. We can't really open the windows because we're hoping that they're done with the stairs, but but the ambient street noise and the 17 trips, it seems like, that they make to the towers for an ambulance and those sort of things like that. So we were looking at, can we get some of these larger units that are out there? But in a 3,000 square foot courtroom, I mean, most of these units will do 1,200 square feet. So we think it would take probably 3 units. The last is we'd like to build some more plexiglass screens. I think you've seen, we built those, the court people actually built those screens that are there. But when you actually go to try a case, what we found with, and it's understandable, some of the lawyers did not really want to be that close to their clients, but they're going to have to be close enough that they can converse back and forth. And so we were looking at to build some more screens that we could put on the table. I've got a couple public defenders that ring the bell on every risk factor for COVID. And yet they're going to have to be in that courtroom if we're going to try any cases. And that's why we were looking for some additional plexiglass screens. I just don't think we contemplated, I didn't contemplate one on the podium. I mean, we went back to requiring the podium because everybody kept wandering around the courtroom. Well, if you're wandering around the courtroom and arguing and speaking forcefully, you know, you look like a super spreader. So I've made everybody stay at the podium, but we're looking at putting a plexiglass in front of the podium for that. So that's the worker safety, that primarily to protect the people who work at the courts, because we don't, you know, have a whole lot of control of who comes in the building. We've only had one person that we located sitting in the hallway say, oh yeah, I tested positive for COVID. Okay, we got them out of the building. I mean, people, they just don't see it quite the way that the rest of us see it, and we're trying extremely hard to not have the staff be the people, the vector that brings them in the building. Continuity of operations. I think I've been here every day but 2 since the craziness started. I think Judge Walker's been here most days, except for I think he was picking his kids up from Louisiana. And so we've tried to continue as much as we can. I mean, simply rolling it over. The difference between this time and the first time is we have a better plan for rolling stuff over. So we're not just continuing stuff out there. And it's extremely critical that we continue operations both in the civil and criminal arena, if for no other reason is most people, if they don't come to court in 90 days, they forget they have a case. And then I have to call my friend the sheriff to go find them, to explain to them the error of their ways. So what we looked at for there, Judge Green didn't have any video in his courtroom to run these. Like I just did a hearing between two lawyers on a discovery dispute, which I did in my office with the video camera. That's about $125. One of the things we learned in the courtroom doing juvenile hearings, and I probably have done 300 to 400 of those via video, is the one microphone is not enough. And so our room unit, our Polycom unit, supports 2 microphones, but you have to buy their microphone, and instead of something that was reasonable, they want $300 for that microphone. But what that does is I've got one borrowed that they said I could have for a week to test it. And one of the things we've tried to do is test everything, because I got a box of AV equipment that we tried the first 2 weeks trying to make something work. And I ran the first 2 weeks of court off my iPad. But I'm the only guy who can see it, and that's a problem for like the court reporters and anybody else in the courtroom. We looked at, and I thought I would be trying today, a civil jury trial off-site. So that's the next area for continuity of operations is, right, we've found so far will cost us $400 a day, and we'd like to be able to at least offer civil jury trials. You know, we haven't done anything since March. I mean, I canceled 10 days of trial the first 20 days of COVID. I set 31 3-day or longer jury trials in the year 2021, obviously on top of each other in second and third settings. But if we go off-site, then I can have 50 or 60 people at a time, social distancing, to pick a jury, and then I can try the case in these venues. The only thing we can't do in the venues we've found so far is jury deliberations, because we don't have a big enough room. Our jury room is just about enough. And so our plan was to pick the jury in this large venue, try the case in this larger venue, and then bring them back here simply for deliberations, because we had the facilities there. We've measured the jury room, and we could do social distancing just around the periphery of the room here. But, I mean, I'd like to try 10 or days, get 10 or 12 days of civil jury trials in before the end of the year, because, I mean, this is the other half of what we do. Is, you know, and we've got citizens out there whose rights have been abridged. They're entitled to their day in court, and we've been scrambling just to try criminals. So that's one way that we believe that we could try off-site, is by moving them off-site, because we have a larger venue. You're looking at a room with, you know, 8,000 to 9,000 square feet as opposed to the 3 that we have. And so that's what that request is about. We're not going to move criminal trials off-site. There was some discussion of it, and some counties have done it, but from a security point of view, you're talking about moving an in-custody defendant to an off-site venue. You know, you got a whole separate operation just for that security aspect of it, and we were of the opinion that it was just too much payroll involved to conduct a criminal jury trial off-site. I'm sitting on probably 9 murders. You can ask the sheriff. We filled your jail up with murder 2, robbery 1st, assault 1st.
I have 112 state prisoners right now.
Okay, and virtually all of them are bad people. I don't know that.
Absolutely.
If you've not looked at the jail roster, I mean, when I started in this business in '07, you'd have 3 or 4 or maybe 5 people like this. I mean, our jail is full of people who need to be in jail. I mean, the stuff they're charged with is serious stuff, and we just keep pushing, trying to get a trial. We think we'll get one tried next week. But I thought we were going to get one tried the first week of August, and that didn't go. So then we looked at, how do you comply with the social distancing? How do you comply with the public access? I mean, public access is a constitutionally guaranteed right that people have to public access their trial. Well, if I can only put 15 people in the jury room, and they're the, meaning in the courtroom, in the gallery, and they're the jury, where am I gonna put visitors? We think we can stream it. We think we can use our existing Polycom equipment that we have in most of our courtrooms to stream it, and that's what we're gonna do next week. Because the victim people are not happy with the defendant people, and they can all sit at home and be unhappy with each other, as opposed to bringing them to the courthouse. We originally looked at the courthouse, but like in Judge Green's courtroom, Judge Walker's courtroom, we can put 6 people. And then I gotta have somebody down there to make sure everybody behaves. So what we looked at is the other problem we ran into is if you go in my courtroom and you sit in the farthest seat from the witness chair, you are 23 feet from the witness. Now you think about this for a second. One of the biggest and the hardest things with masks are watching people testify, trying to decide whether or not they're telling the truth, which is the job of the judge, which is the job of every member of that jury. And when they're sitting there behind the mask, you really have no clue, because you can't see their facial expressions and how they react. So what we did was, in the one case, we ran a test trial. We tried a DWI case. Is we put the witness in the witness chair, and we put a camera on the witness. And then we moved that camera back to the middle of the courtroom in the front of the gallery. Now, fortunately, because of the tornado, I have an extra television. My wife has said I can't leave the television here, but at this time, so we put a television in there, and so instead of being 43 feet from the witness, they're going to be in the 20-21 range at the farthest point in the courtroom. And so what we're proposing is 2 televisions, one on each corner of the courtroom, so that the people sitting in the gallery, who are the jury, on their little blue squares, are approximately the same distance from the picture, and if you use a 50-inch television, it's about life size. We tried that in our test case. We asked the jurors, we talked to them before the trial, during the trial, after the trial, and that was one of the things that made a tremendous difference in conducting these trials, is they could see the witness, because they were up on, for lack of a better word, the Jumbotron. So what we're proposing here are 2 televisions on carts that we can roll out, so that the people sitting in the gallery have essentially the same view as they would have had they sat in the jury box. The most people I can put in a jury box is 3, and the Constitution requires me to have 12. So, I don't have a video unit in the 4th floor jury room, but the other things that we could do in those cases where we had limited public requests for trials, we could put TVs in those courtrooms and broadcast to those televisions, and that's what the second request for television. So I want 2 for my courtroom for the Jumbotron, and we think that we could take 2 in the other courtrooms, would allow them to do that. If you look in both courtrooms, those TVs are set up for the judge, for basically the jail videos, and so unless the visitors to the courtroom are sitting in the judge's chair, they can't see. And so that was the reason for the second thing there. So we sort of laid that out. We'd like a wireless microphone system, because I just couldn't get the witness and the microphone together. I mean, it's just not natural to sit there to do that. And the same thing with the lawyers that speak. And that was the big difference. The sound system we have is adequate for sitting in the back and hearing, if I can get the people to use the microphones. And so what we're going to use is 2 portable lavalier mics, so we don't have to worry about them leaning into the microphone, which you're not anticipating, and then screws the sound all up too. So that's what that request goes to do there. We've borrowed this equipment from other people. We've tested it. We think that this is the combination of equipment that will allow us to effectively have jury trials. Last but not least, the 2 things we really have we're going to talk about is personnel. And we're not talking about, high technical personnel. We're just simply talking about hands. And if you think about this, every clerk who works in the building has a public component to what they do, whether it's going to meet people or pick up stuff or move stuff or do something, and they have the data entry part of it. I can move the data entry home, but their arms are not long enough to reach the courthouse. And what we were proposing is just some money for part-time staffing to address that part of it. which we lose because, for example, I have to have somebody downstairs checking in everybody on a law day. Right now, there's somebody down, we're doing it with marshals, but then I don't have enough marshals when all the courtrooms are operating. To check in that, like Cotton's only doing felonies. And so we're turning away and giving a new date to the misdemeanors. In my docket, they go through and we figure out who has to come upstairs and who can be given a new court date. We did law day mostly by video last week, and with some hitches it seemed to work okay. But there's still a need for someone to take this piece of paper and move it to this piece of paper, and I've sent half the clerks home. They're all working from home, and so they can do the clerical part of that, but there's not enough people to do, and sometimes it's as simple as answering the phone. And at the same time, everybody's trying to call in, you're increasing your phone demand, we were also sending everybody home. And so what we were looking at was just some part-time staff that we could employ to assist, be it with the clerk's office, be it with the marshal's office, or cleaning. Nobody cleans our building. It just doesn't happen, okay? I think we have excellent maintenance issues, but nobody cleans our building, and we've sort of hodgepodge through over the last 10 or 15 years using community service people, which we do not have access to during COVID with the courthouse being closed. And so the two things we're asking about is having somebody come in and clean the building. And then, so we could take these part-time people, which we're proposing, one of their jobs could be to go do that sort of extra cleaning that everybody else is doing, whether it's doorknobs, bathroom doors, bathroom fixtures, all these public touch areas, all these counters with the public areas that we could use for that, because we've got nobody who does that. We've got nobody who does that in the regular world, but the need is not as high. And so that was what we proposed. Were two things there with cleaning was, some staffing, at $350 a month, at 350 hours a month, that's 2 FTEs, which we propose using it like 4 part-time people so we don't create the 29-hour benefits problem. And then hiring somebody to come in to actually clean the building. Maybe once a month during this thing. That's what everybody else is doing out there in industry. And we don't have people. We don't have people who clean the building now. And the need is greatly reduced. So that's the basis of that request.
Does the deep cleaning include sanitization too?
Well, I think the deep clean would at that instant in time, once the deep clean was, you would have the same thing as sanitization, but that's gonna be good until the next person comes in.
Well, some of it, I guess, sticks around and fights some of the
Yeah,
things
depends on
for
the
an
product
amount of
used.
time, so.
Right now, I think we spray a lot of Lysol. But if nothing else, I think the visibility of cleaning people helps the people who come in the building feel comfortable, because no one wants to come to court. I mean, nobody comes to court, adoption people aside. No one comes to court voluntarily. Jurors don't want to come to court. Defendants don't want to come to court. Lawyers, probably if they had their druthers, don't want to come to court. And, we're looking at those things which we can do to increase, the building. I mean, I got every grocery store in town that are wiping off the touch pads, they're wiping off the thing that moves your groceries along and those sorts of things like that, and we've got none of that. But we still have people coming in the building, leaning on the counters, touching the doors, working through the building, using the bathrooms and things like that. And we think that both needs to be addressed on a daily basis and then on a summary basis or a monthly basis.
I think all the other stuff, keep government running, and it was all reasonable, but the last part, I think that should more or less be under maintenance. So wherever it comes from or goes to.
I think Greg has ordered, I don't know when we're gonna get them, but didn't he order like 2?
We're working on that.
Yeah, so I don't know what the time frame on that is. I know the schools were using those, and like they're doing the bathrooms in the halls while the students are in class, and they do that over and over, but,
I think we talk about anything.
yeah,
I mean,
but I'm just wondering.
I'm fine with you all being in charge of it, because you know what your wants and needs are over there, so it may be beneficial for you to do it, but at the same time, we have our own maintenance department, so which way do we want to handle that? I think it does need to be addressed, so. So are we just talking today about submitting this to BKD?
Yes.
Okay.
I'm basically good too. I'm like Jeff, I think maybe we need to look at options for the cleaning part, but all the other, I mean, we're talking 110-year-old building that, you know, these are different times altogether, so.
well, like I said, we went through it, interviewed all of our people. We said, you know, what do you do, what do you need done to continue operations, to be safe? And you know, this is the kind of, based on the responses that we got, we developed this information here of how could we, you know, continue operations, because I got to tell you, you know, if people don't think that we're in operations, whatever deterrent effect going to jail has is diminished. And we have been able to, you know, we are taking pleas, we are trying to move cases forward, but I mean, everything takes twice as long. And, you know, so like I said, the last part of it is that's sort of a generic staff request. I don't want to diminish the part that we just need some hands for the people who are not in the building. We moved the clerks off-site because, you know, they can do a lot of the work remotely, but they can't do the moving the paper from A to B. And, you know, helping us out, you know, it's taken at least one extra person per docket. Just if nothing more, to make sure that, you know, just walk through the hallways and say, hey, look, sit in the blue spots. So. Other questions? I mean, you know, I don't, like I said, these are what our needs are. This is what we think it takes to meet those needs. But I realize that, you know, these fit in different parts of your budget, and so, you know, my job is to kind of explain what the needs are. If there's a better way of doing it, or it fits in your budget a different way, we're all for that, but we need somebody going around wiping off doorknobs, handles, on the counters people lean on, you know, as they come through security and stuff like that.
One person per person coming in.
I don't know, we need to. I don't know, they showed me a picture on the internet of a guy going to Walmart with an umbrella and a clear plastic bag over him. You know, I don't know that we quite need to do that, but we're gonna have to get, you know, people through the building. You know,
Tyvek suits and gloves for everybody. I don't have any more questions about it. I think send it to BKD and see if they qualify, and we can go from there.
Yeah, I'm good too.
Yep,
okay.
okay.
Thank you so much.
Thank you,
John.
sir.
Thanks, Judge.
Okay, we will go back to approval of CARES Act signing of subrecipient agreement.
We don't have any today.
Okay. And we will go to second and final reading of budget adjustment number 18.
This is for $8,891.46, and this is the law enforcement, and this was a couple checks that we received from insurance proceeds. So I do need action today in signing of this, to put it back in their insurance account.
Yay.
I move that we sign court order number 18.
Second.
All in favor?
Aye.
Okay, assessor's office to present occupancy plus errors and admissions. I can't talk very well today.
Good morning.
Good morning,
Morning.
Jackie.
I had sent everybody the Excel sheet that had occupancy, and then the second tab was errors and omissions. I did hand everybody a new sheet because close to the bottom, we had 2127 Hampshire. She called this morning and changed a couple things on hers that we had estimated on. So there's an adjustment on that line. And then on page 2, you have the errors and omissions.
Yeah, I think we want to discuss the Jesse Ferris, West Brazito Road.
You have questions on that one, or you're discussing it separate?
Well, why was it never assessed?
It was assessed.
Oh,
No, field staff had not picked up the new house he built back in, I believe it was 2011?
But did you have an assessment for the parcel whatsoever?
Yes,
Okay,
with an outbuilding in the land.
okay.
So just the house portion he had built had not been picked up.
But the property had been assessed for those years, which it is the house.
Correct.
Okay.
okay.
So I have an attorney general's opinion. An assessor cannot assess real property in subsequent years for any prior year in which such real estate was assessed, even though the assessor was not aware of the fact that improvements were on such land on January 1 of the prior year, when the land and the improvements were owned by the same person as of January 1 of the prior year. So in other words, if you have an assessment, even though it's incorrect, you cannot go back for a redo. Now, if the property had never been assessed at all, you know, like it's not on the tax roll, something like that, then you can go back. Because the person knows he owns the property, and he knows it's not being taxed.
Mhm.
So, he should be responsible. But in this case, when you do that, the person can't go to the BOE and challenge your corrected assessment at this point. So, there are statutes that allow you to go back if no assessment was done whatsoever. There is no statute that allows you to go back and have a redo.
So are you saying we can't tax him till what, 2021?
Yes.
Or are you saying even 2020 could we put him on?
You've already done the assessment for this year,
Mhm.
so it would have to wait till 2021.
I'd like to point out just the fact that the reason that we're doing the way we're doing is because that's what the chief counsel at the Missouri State Tax Commission recommended.
Prior.
Go back to 3 years.
But that's
Yeah.
probably for a property that hasn't been assessed. There's a difference.
That wasn't the case with the question that was presented to them,
Are you talking about the memo from Maureen?
possibly.
Yeah, well, I have that, and in fact, what that was about is she was pointing out that errors and omissions are not to be used for valuation errors. They're only to be used for clerical errors. And if you think about the policy behind that, people need to be able to appeal their assessments. And so when you go around doing a do-over, and they have no means to challenge that at all, I mean, you're probably depriving them of due process.
Couldn't he appeal to the State Tax Commission by
No.
September 30th?
No, he can't go back 3 years, appealing 3 years of assessments. Plus, the collector needs to know a sum certain of what the taxes are that he's going to get for that year. I mean, what if it's the other way around? What if you've been overvaluing property? Say you have that property assessed at $400,000, and then you turn around and say, well, this is over assessed, so let's drop it by 25%, and it's now valued at $300,000. Did you go back and have the collector refund taxes for the previous 3 years? I mean, it goes both ways. So the laws I found, I have the Attorney General's opinion that says this. If there's no valuation whatsoever, no assessment whatsoever, the law doesn't say how far back, but I think 3 years typically is kind of statute of limitations. But if there is an assessment there, you can't have a do-over after the deadline.
I have a question. That's a Attorney General opinion, it's not a court opinion?
No, because there's no reason to have one, because I guess, people don't do it.
But an opinion from attorney is just an opinion to that, and it
I don't
has no
disagree, Chris.
basis in court,
But
is that
it's, but
correct?
it's more than there
I'm
is.
just asking a question.
Yes,
Bill.
that's true.
Okay.
But there's more than there is saying you can. And I mean, think about the policy reason. I mean, when you devalued your house, did you go back the 3 years and change the assessment for the previous years and have the collector refund taxes?
Well, obviously not, because I didn't own it at that time.
At any rate, my point being is this is what I found, I mean, I can't tell you what to do.
The other thing I would like to mention, and I don't know if this has any bearing on it or not, it is in statute that if somebody fails to provide the information to the assessor, if they intentionally try to avoid it, we can go back for back taxes and penalties. So I don't know if that has any bearing on this situation or not.
Do we know that he intentionally,
He did not report anything to us. He continued to receive a bill for the original parcel, and he had a combination shop house. They call it a shop. It's like a third of the building is living quarters, and the rest of it is a working shop.
I'd like to look at that because I've seen a statute like that, but I think it applies to personal property.
okay.
I just want to point out one thing. Mr. Ferris has never gotten a tax bill. He escrows his payment, it goes to CoreLogic. We bill them electronically. We don't send taxpayers a copy of their tax bill if they're paid through CoreLogic, or they're paid received.
But he is notified if his escrow has to change.
I don't know. You'd have to ask CoreLogic that. We don't deal with that.
That's
He gets an
standard.
assessment sheet, so, right? Still
Pardon?
gets an assessment sheet.
The assessment sheet is actually only for personal property, and the only way he would get a notification from us on his real estate would be if we had an increase, and he was sent an increase.
So when was the house in question built?
Between 11 and 12.
And so we're supposed to be doing a reassessment every 2 years and visiting the property, and how come we didn't catch this?
I honestly couldn't tell you. I can tell you that the person that took the photographs was supposed to come back to the office and enter the information. They failed to do that. That person's no longer with the office. And they were responsible for taking care of the assessment during that time. And I can't tell you why they missed it. Probably because of the number of employees we have and the number of parcels we have.
So this actually goes back 9 years.
Correct.
So it sounds like we made a mistake, so it's our mistake, and we just need to do what we can do moving forward.
If that's what you guys want to do, that's fine. I spoke to the property owner. He said he didn't have a problem with it, but if, that's the way you want to handle it, that's fine.
To me, that's the only fair thing to do.
Come on,
There
argue.
was this little thing that happened a few years ago about a surtax. That was our mistake too, but we didn't forgive anything there.
Well, I don't know when Chris spoke to Mr. Ferris. I spoke to him, he told me he spoke to Chris first. He was very upset when I spoke to him and told me there's no way he could come up with the $14,000 in taxes he would owe. Now, he did say he was fine with the 2020 year, but he was not fine with the prior years.
I calculated an approximate tax bill for him sometime last week. I got to him the first of the week, I believe, so it was the first part of last week that I sent him estimation on what his tax bill might be, but I did inform him that that wouldn't necessarily be exactly the amount.
And as I said, he called me after he spoke with you.
What was that he spoke to you? Do you remember?
I have it on paper downstairs, I think it was Tuesday or something. He said he talked to you, and you told him to call me. So
That might have been the same day. Well, I told him to call you several times because he had questions about whether he could make payments on it. And I said I didn't have that information. He would have to ask you about that. And that was prior to me giving him the estimate of the amount. And that's all moot point. It's just what you gentlemen up there decide to do is what's right.
I think just go for 2020.
I don't think he can.
You don't even think we can go 2020?
He can't go, he doesn't have,
I mean, for the errors and omissions, we adjust it right now.
errors and omissions are for clerical errors, not valuation errors. It's too late for him to go to the BOE and challenge that assessed valuation.
Okay.
If I can make a point here, it is a clerical error because that piece of property was not put into the system. So the house itself, there was no assessment on that house at any point. Completely new house, had never been valued by us in our system. So it was an omission that we had to put into the system.
It does not fit under that.
You're the attorney, you make the call there.
I can produce Maureen's
I take your word
memo
for it,
to
it's
you.
not necessary, it's not
Okay.
necessary. I'm just telling you what I've been told and.
Well,
the way
that's not
things
what she
operate.
told you. And I have
I'm
that
sorry?
memo. That's not what Maureen told you.
So we can't do anything to it right now technically, is what you're saying, and
Right,
Until a new
until
tax.
2021.
21, we can change the the valuation.
Right.
Okay. So, I mean, I think we made the error, so, I mean, I agree.
I think if we didn't discover a house for 9 years that was on a lot,
Well, I can argue the other side of it. You've seen some of the houses, you can't tell the difference.
This isn't a house, this is a house.
Oh, I thought it was a
It's a
house.
separate structure.
Yeah,
Yeah.
there
No,
was a
the house
shop
was-
there.
Okay.
There was a shop there, now there's a brick house. It's a
we just missed it.
single
It's
level
out in
house.
the rural area,
House.
a ways down the driveway. So it's not visible from the road.
It is visible from the road, Chris, because I've been there.
Okay, my
So-
mistake, I got the incorrect information then.
Anyway.
I myself haven't
It's
been
on,
there.
it's on a blacktop road on West Brazito Road. It's, should have been caught, so. I mean, I'll move to approve, but I want that one removed, so,
Till 2021.
yes.
Yes.
I move that we approve the errors and omissions with the exception of the Jesse Ferris property.
Second.
All in favor?
Aye.
Okay.
Thank you.
Assessor to discuss Lewis, Reed, and Allen invoices.
Do you gentlemen have copies of the bill this time?
I do not.
There's nothing attached to the,
Who was it that put
Agenda.
us on the agenda the first time? Do you know? Because I got an invitation to come over and talk about those, but I wasn't sure where that came from.
Last week, and we didn't have the information, so I put it on this week. Assuming you didn't bring the information.
yeah, I thought it just carried over because we didn't have the.
Invoices,
bills.
so-
Now, I would have thought that finance had got you those. I've got some copies here that I guess we can make copies of if you need. I know that the bills were sent to your office.
didn't-
Let me get
I
the
did not
right
get any.
page here. I think this,
Did you?
I'm trying to refresh my memory
This
exactly
is
where we
the
were at
second
the last time. 'Cause
Yeah.
I know we were talking about the agreement and then the percentages, and we don't have an agreement for this year. I think we've got an agreement, but it's not signed.
yeah, and I didn't receive the bill or the contract until July 27th. And then I had to send it back to them because it hadn't been completed. They hadn't provided all the information that was needed.
Right.
And then we had a conversation, was it the 24th, I believe, about whether or not we were gonna go forward. And then, I guess somebody heard from Cape County, and they thought that we were gonna move forward with the appeal, and we ultimately decided not to. Did any of you gentlemen get a call from Cape County Commissioner?
I did
Cape
not.
Girardeau?
I had talked to Clint, the presiding commissioner. It's been several months ago, but that was just about moving forward. It wasn't about,
Yeah, that would have been the, I think it was July 27th conversation that I was notified about. And Sam, I sent something to talk to you, and I sent an email on that on the 24th, asking if you had rethought your decision of July 14th. And then you decided on the 29th that we were no longer going to go forward with this. So I think with the billing, there were 2 dates that were after the attorneys received notification that we were dropping it. So I think it's 2 items on July 29th, which should not be valid.
So did we actually end the appeal? Because I thought they were wanting us to stay in the appeal because our name's on the case for whatever reason, Jill.
You all decided that you were no longer going to fund the appeal. Chris
Okay,
is
so
being
there's
named
a-
defendant, so ultimately it's his decision, but it's your decision whether you're gonna pay for that defense.
And I'm certainly not going to go forward with it if you're not going to pay it.
That would be hard.
Yeah.
I mean, as it is now, you've incurred these bills on your part, and they don't have a signed
But
contract.
if Cape's wanting to keep fighting and we're on the case, then does it have to keep going with us on it even though we're not gonna
They
fund
have
it if
other
they wanna
cases.
fund
No.
it?
The
They have
schools
other
actually
cases.
pay
That's a,
Cape's part.
I understand, but you have the case.
This
It doesn't
one-
say the schools on it. It says Chris Estes, it says,
Yeah.
So it
assessor for
is,
Cape,
Jeff, it is.
so.
But
So
they-
then if
they
Cape
have-
wants to keep theirs going, I thought theirs was part of the same case.
No, they're each separate cases because they have to be, they're in their own counties. The one in Cole County,
So then how are we footing a bill for a portion of a case that is our case?
because everybody agreed to see what happens in this one before they go forward with their cases.
With just a little explanation, Jeff, when we started this back in 2013, there were 19 counties that got together and we got into the joint defense agreement, agreeing that each county would pay a percentage of the whole.
Ours?
Of all the cases, yeah, because we had one attorney and one
Because now you're saying
specialist.
it's the other counties'
Well,
cases.
they have their own cases, but they went forward with this one. It's like the test case.
2013 is dead for everybody.
Is it dead for everybody now?
Dead for everybody. That's what the State Tax Commission ruled.
Well,
Yeah.
Cole County was the lead litigant, and when Cole County didn't continue, that killed it for everybody.
well, and then that's
that
based
correct,
on
Chris?
the state tax commission's findings
That's what I
too.
read in the
I think that's what the
That's true,
opinion
because-
said.
Because everybody else agreed to be bound by what occurred.
In
in
2013 with Cole
case.
County,
Yeah, now I
yes.
remember that, okay.
So 2013 is
So that's
a
all we're
done
talking
deal.
about is 2013. The 14 to 21, which they just filed, or 20, which they just filed, is still ongoing.
And like I said, I think you'll see on the last page, there were 2 items, one on July 30th and one on July 31st that should not have been billed to us because they were notified on the 29th that we were officially dropping. And you'll see, I think at the end of the bill, you'll see the billing summary, which gives you the total amount, and then they've calculated out what Cole County's portion was supposed to be, except that the notification on the portion changing didn't arrive until and that was because different counties dropped out. You know, I received that on July 9th of this year. And they'd been contacted at least 6 times to get us a contract for 2020. And finally, after our Board of Equalization, when we talked about not going forward anymore, I let them know that, look, we've got to get something done. You got to decide what you're going to do, give us a contract or not. And I sent another request at that time, and then I got the one I have, but it wasn't completely, we needed some more signature lines, I think, is the reason it went back, just as it has in the past.
So I'm still where I was the other week. They were working without a contract. We don't owe them for any of this, and so I wouldn't pay any of it.
That's kind of the way I feel too. And I'm like,
I mean, if you're not a good business person, you don't get a signed contract ahead of time, you can't bill somebody for work you don't have a contract for. So,
You know, with the county not being the named party, they can't come after you because the assessor is actually the defendant.
so you asked him 6 times this year for a contract.
The very first one I have is January 17th at 1:11 PM. I emailed them, said, we got to get a contract for this year. Because, and we've had to do this almost every year. For some reason, I guess some counties don't do a new contract every year, so they were not automatically doing a new contract. So I had to call them every year and tell them, we need a contract for this year.
I'm with Chris. I just, if it doesn't have a contract, I don't know why we would pay him.
And I don't, Jill, you would have to let us know. I don't know if the joint defense agreement item would be anything that would bind us or not. I have no idea.
Well, you have no contract for this year. I mean, that has to be something.
Correct. We don't have a contract for
And
2020.
for last year, because we had no contract for any percentages, and Kristen, correct me if I'm wrong here, but I think the only contract we had was with the 23%.
Right, I don't think we ever signed anything
Yeah.
So
changing
you
that.
know
I think that's right.
But
35%
Be aware,
is-
though, you have incurred their services. So they may come after you,
The assessor of Cole County.
because you're the named defendant.
Yes,
and
I
the
understand
services
that.
were performed for you.
Yes.
So, yeah, I mean, I don't know how much harder you can try, but
Yeah, I mean, you know, I've tried to get the contract. They failed to send a contract. I've let them know constantly that they need to get us a contract. We have to have a new contract every year. And even when they send it, they still don't send it in the correct form that we ask it for, or ask for it. Yeah, and this case has been paid out of the assessment fund anyway. I mean, there's been no general revenue spent on it, and I don't know if any schools have contributed any to it. I know you gentlemen approached some of the schools, but I don't know what came of that.
Larry Lifton was on vacation when I reached out to him.
This last time, yeah, I remember that. I thought we'd had them in a couple of years ago.
We did,
And
yeah,
spoke to, but I
we
don't know
did.
what the outcome of
And I
that
don't
was.
think- I don't,
No outcome, there's no
No.
good outcome there.
I don't think so.
Yeah, yeah, and when they're, 87% or thereabouts of what the amount is gonna be funds for them.
So we went from 23% to 35%.
Yeah, because different
Yeah.
counties dropped out and it got divided up to different ones, but they never sent anything out to us to change that percentage.
I'm still for not paying it.
I am
so-
too.
So,
So, I'm s-
Will you all draft something to send to something to them, or do I need to do that?
That's from you, because you're
Okay.
the client.
So we did have a contract for 2019 at the old percentage, so
Right.
we need to pay those bills at the old percentage
Right.
That are in that year.
Yeah.
in that year. And
Yes.
then anything for 2020, we would not be paying.
Right, you don't have a contract.
Okay.
Okay.
so that's just,
what's that amount to? It's like $250 at 23%?
That is just, I don't think that the, what I have for 2019 is all inclusive, I'm not sure.
There's only two items on there that you have, that 2019, and they're two small amounts, $200.
Well, we
9.5.
had-
yeah,
So was this one
9.5,
taken
10.2,
care of? This is
10.4.
one from
Another page.
the 30th
oh,
on 19, and it had some numbers in the back here, so I don't know if that was your writing or. Yeah,
That's the very first page.
So they
yeah, I
got
was
it
just
right
looking
here.
at these two here.
Or a portion of it.
Yeah, I don't know where I had that one too, so I don't know. Oh, maybe that's for 14 and a 15.
So Chris, was there anything in there that you
We
had
never even had a contract for that.
specifically yourself talked to them about or asked them to do? I see a couple of things about some email exchanges, and if they're billing us for us emailing them about billing us, then that's ridiculous.
Well, I would tend to agree with you there.
There's, I mean, if we ask them to do something for us, you know, if somebody comes in and fixes your refrigerator, you don't sign a contract for it, they're just gonna send you a bill. So, if we ask them to do something, I'd be curious what we actually had them do for us. And you got two people saying don't pay the bill. I would tend to agree, do not pay this bill as it's written right now.
What occurred with the 2013 case is it went through, and I'll try to do this fairly brief. We had 19 different counties, 19 different boards of equalization approve the assessor's value. Those 19 cases went to 16 different circuit courts in the state. The 16 different circuit courts approved the assessor's value. That went, I'm sorry, it went to the State Tax Commission hearing officer after the Board of Equalization. The hearing officer ruled in favor of the assessor 19 times. The state tax commissioners, the 3 commissioners, signed off on those ruling for the assessor 19 times. Then they went to the circuit court. All 19 cases were ruled in favor of the assessor. Then we went to the appellate court, Western District, and they ruled against us. And then the other 2 appellate courts ruled very similar to what the Western did. So that sent us all the way back to the hearing officer, which is the step after the Board of Equalization. Went through the hearing officer, and it took a very long time to get a decision on that. And during that time, I believe, and correct me if I'm wrong, Jill, that the group had decided to let Cole County be the lead case in that, and whatever the outcome of Cole County for the 2013 was going to be what the others agreed to.
I guess, Chris, I mean, you were at the client meetings, I wasn't there.
Right,
so-
yes,
I
I
mean,
was.
that sounds right to me.
Yeah, but the contracts all went through your office. I don't know if you would remember
Well,
that or
there's
not.
just the joint defense, and then there's just the representation. There was no detail about how the case was being handled.
Okay.
procedure. It's just a typical letter of engagement, and then the joint defense between the counties.
Okay.
So, but I mean, that sounds about right, because then what happened then is the actual state tax commission took the hearing officer's opinion and came up with theirs. And the most fatal part about all of this is, as far as an expert witness, they just shot San Souci out of the sky. So, and I think that's when Lewis Reed now
That's-
threw in the towel,
That's when they,
because they're,
Yeah,
they
the
have
last-
no credible expert witness.
yeah. That's what the hearing officer ruled in the last case, yes, for 2013.
so I would pay the 2019, and then we'll,
1.3%.
yeah.
Well, 'cause- 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 So it was just these two, correct? Okay.
I thought Morgan sent me one that was just a $50 one. I just forwarded it. So that one.
I say we put Chris's name on any other lawsuits too, so we come after him. So, John, you probably
Yeah,
got
okay, the
that
one,
on there
that's,
too.
yeah, that's the one.
Got a few, we
I have
just
that
walk
one. Okay.
Jeffrey.
We usually pick on LV, but you're here today, Chris.
Oh, believe me, I understand.
I'm off and switching over to Larry now, if we want to.
Oh, we're gonna get in animal control.
Everybody has their day in the barrel.
That's right. That's exactly right.
Okay. Anything else on that? Okay.
Better move on after that one.
Gotta be nice, come on. Okay. Then we will move on. Discussion of the courthouse site improvement project.
So you're all done with me?
Yes, thank
Have a good
you,
one.
Chris.
Any other questions, just give me a call. Thanks.
Okay.
And I'll send something to Lewis, Reed, and Allen.
Let's see, we got an email about this too. This is about the billing.
Yes.
You know when you sent that?
What was the next thing, I'm sorry?
For the billing for the
Oh.
courthouse improvements.
That was me, sorry. Looks like September 1st. Basically, we're getting close to the end of that contract, and I know when the architects were here with their punch list of things that still needed to be done, on the top of that letter, there was a suggestion of how much liquidated damages that we should assess based on the $750 a day calendar. So I just need to know if that was actually approved. I don't believe that was actually approved that day. I know you got the punch list of things that want to be done. But since we're getting close to the end of this, I need to know if you're going to assess that liquidated damage of $20,250 to this project. So I can make sure we don't pay that. And if you agree with what Central Missouri Professional Services came up with.
Yeah, I think we almost have to. GBH has done a great job. I really do appreciate them stepping up and rectifying it that,
Okay, I guess I'm not understanding the email then. You're saying we've got two payments, 46 and some change, and 76 and some change, and then after those are processed, we would still owe 53 and some change, which would cover any calculated liquidated damages at this point, in addition to the 5% retainage, right? It would still have it covered, so we can go ahead and process those payments.
They're in there and they are.
Okay.
You just approved those today in accounts payable. So I'm sure I will get another one very shortly. Those two bills came very quickly next to each other. So I'm sure I'll be getting payment request number 9. And then, holding the retainage till all the punch list is done. And then just need to know if you want to do that or not. Or I can bring it up another time if you want, once I get the next bill.
I think that previously we've held the liquidated damages, and if they want to come and, I guess, basically appeal it or have reasons for it being late, then we deal with it then. So I would still hold it. Is that what you're asking?
Yeah, I just need to know.
Are you currently holding that amount plus the retainage?
I would. That's what we've done before.
So that's what she's asking.
So I'm not seeing any reason to do it any different.
Okay.
Why change now?
yeah.
I mean, truly don't remember the last time we had liquidated damages. been a while.
Well,
It was a
I mean,
subdivision.
considering that was supposed to be
Redoing some
done
roads.
Parkview Meadows, yep.
Yeah.
the first week in June, and here we're in September. And I do appreciate GBH has, stepped up, but
Okay, I'll hold it
Yeah.
and then I'll bring it back at that point, when we get to the end.
okay. Signing of surplus title.
This is for a vehicle that we've been waiting on. We had to apply for lost title. This was Road and Bridges vehicle that got,
God, I've signed a lot. I've signed a lot.
I don't this stuff back.
Yes.
I move that we sign the surplus title.
Second.
All in favor?
Aye.
Aye, okay. Emergency purchase report, the building modifications.
Can I back up just a little bit on the other deal so I'm clear on some stuff and so we're all on the same page?
Do
I
you
know
have
we
a
talked-
king card?
Excuse me?
Do you have a king card for the reverse card or whatever? You have to have a reverse card.
I'm sorry, I didn't bring it. On the, we were talking about the mannequins and so on and so forth. I know iSimulate was discussed. Has that been to BKD, the iSimulate yet, Debbie, or does that need to go on to BKD? The iSimulate's the,
Mannequin.
no, the waveform part of it that goes along that simulates the monitor and the vent settings and all that. I don't think that's been to BKD yet.
Was there an application for that?
I believe so.
Well, then they would have had it if they.
I don't remember that.
I don't remember.
No.
If it hasn't been. we
I know
can
for the
put that
monitors, we
forward.
did the brackets for the monitors, but I don't
Yeah, but
remember.
this would be for simulation of waveforms, simulation of the monitors and simulation of the vent settings. Very good, sir, thank you. Excuse me?
Oh, I'll get back to.
Well, yeah, I get it. Let's see here.
Guess we scanned.
Yeah, because I think that.
Is it not on that?
I don't think so, I don't see it there, no. It's- Anyway, if it isn't, and I don't see it there, can we get permission to send that to BKD to take a look at? Because it's like $9,900 for all the, it does the changes, the vent settings, the monitors, and so on and so forth. But if we could get permission to send it on to BKD to look at it, because I know we talked about it in here, but I don't see it on there. So I don't think it's going to be BKD.
Does that need to be done with the mannequins? Is that what you're
Yeah,
saying?
that's basically what I'm saying, yeah.
Yeah, I'm good with sending it.
If we could send it to BK, if I could have permission to send it to BKD, I'll get Debbie the paperwork that it needs, and we'll go from there.
I think it all needs to be submitted together, and
I get it.
then if for whatever reason that doesn't qualify, then we can look at that.
Do you need a motion? Does it need a motion to go to BKD?
I think those first ones were in a motion, weren't they?
The one about the internal application?
Yeah.
To no, the commissioners just need to forward the BKD.
All right.
And this is for the mannequins and simulation?
Yeah, it's basically a program that goes along with it to do
How much was it?
I'll just say simulation.
9,900, I think. I'm doing that by memory, Debbie. I I said, I'm sorry, I got caught. Okay, so we can go up to, if you're ready to the next, I'll bring you some information and so on and so forth. So we had looked at, I think Matt has probably talked to you, but one of our concerns is when we have to social distance people. We've got people stashed over emergency management office, we've got people stashed in the emergency management classroom. We got a bid on moving things around and adding a room, so it would give us a bedroom, separate bedrooms for everybody, so if somebody gets exposed, we're not exposing everybody else. We're trying to social distance. As you guys know, we moved Sandy back over to emergency management to keep her away from the crews, and then when we have people come in, the way things are set up right now, we had some unknowns. So the first part of this that I'm giving you was an estimate that we got on the moving things around. And then that's got the electrical and the HVAC in it. The second part of it is we brought Brian in last week for the IT component, so we knew what we were gonna have to update with the IT component. So there's electrical, HVAC, wood, sheetrock, nails, whatever. And then the last part of it is we're pulling all the IT wires in, and then there's a switch that Brian said we would have to accommodate the extra IT connections. So grand total there, I come up with $27,383.54 it would take to move things around.
I think we need to do that, because it's,
Well, as you know, we're 24/7, and sometimes crews are up all night and have to sleep during the day, and obviously having a bedroom right now in the emergency management office and having a bedroom in the emergency management training room is not ideal, but we're doing the best we can to get along right now. So we would ask for approval to move forward with this emergency purchase.
yeah, I'm good. I think having two to a room is not real smart right now with,
Well, no, sometimes you can have three.
COVID,
because right now,
yeah.
we've only got two bedrooms, and we have, we separate male and female, so you could actually have one female in one room and three males in another room, which we're not doing. We're moving things around, but it's not ideal.
no.
Questions?
I move that we declare this as an emergency purchase and move forward.
Second.
All in favor?
Aye.
There's,
These two together?
no, this is not, this one's yours. She's got one. That's what I have here. Thank you, gentlemen.
Thank you.
Thank you. Anything else before we go into closed session?
I don't think so.
Move that we go into closed session pursuant to section 610.021 of the revised statutes of Missouri for personnel issues, sub 13.
Second.
Roll call?
Sam?
Yes.
Jeff?
Yes.
Chris?
Yes.